going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Oh, I've got a spicy one. This defendant, man, she does not like her attorney. And we know she doesn't like her attorney because she tells us she doesn't like her attorney. She has done everything to this defense attorney that she could possibly do legally. Filed a grievance, went to whatever commission board she says goes. She files everything. She complains about him to everyone. And then she wonders why he doesn't return her phone calls. All right, let's try to break this down. It's a wild one. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Mute, please.
Sorry, my name is Britta Daniels.
Thank you. Ms. Daniels, we're here today for a hearing at your attorney's request. He noticed up this motion to withdraw. Have you had a chance to review that motion to withdraw?
Yes, I have.
Adjust my camera.
Do you want me to move it, Judge?
No, that's okay. Thank
Okay.
you. So, Mr. Fagan, I need to ask you some clarifying questions, and I recognize that based on what you stated in your written motion, your answers might be difficult, and I say difficult because your client has rights that need to be protected. But I need to understand the basis upon which you are seeking to withdraw in a little more clarity. Can you tell me why you're seeking to withdraw?
Yes, Your Honor. It was for frame of reference, I did try a case called Pugh versus Carl Papp. The jury came back guilty. That was in front of Judge Mertz. Ms. Daniels, when I left the courthouse, met me out on the sidewalk, verbally accosted me and blamed me. Has referred to me as a piece of shit, threatened to grieve me, threatened to call the Attorney General's office on me, Attorney Grievance Commission, sue me, take my license. That's just a few of the things. And so on that basis, I can't continue on.
Ms. Daniels, did you wish to be heard regarding those claims or the request by your attorney?
Yes, Your Honor, I would like to be heard.
Go ahead.
I will say that I never threatened or anything Brian outside of the courthouse. All I did was ask him what I am supposed to do now, because for the last year and a half, that man has promised me and my fiance that my fiance was going to walk free and clear. He 100% has failed to do his job in every aspect. During my fiance's trial, he refused to furnish any evidence. He refused to allow me to testify. He cost me thousands of dollars for not doing his job. And I did. I filed a grievance with the Attorney General's Grievance Commission for the lack of him doing his job. He did not furnish any evidence in any aspect. He refused to let me testify. He cost me $220 in babysitting charges for having me sit out in my car for 6 hours waiting to testify. He cost me at least $2,300 in a job I could have done that day instead of waiting in my car to testify. He's cost me so much money. He refused for the last 2 weeks. He has refused to answer my calls, call me back, do any of the above, to the fact point where I called his office this morning to make sure what time my hearing was. He refused to talk to me. I was told that as of from right now, the past, Brian is still my legal representation. He cannot just quit working for me. You have to allow him to quit, is what I was told. But still.
Well, Daniel, so let me clarify the point of law, and then I'll let you continue if you want to. When an attorney takes on representation before the court, the attorney has an obligation to continue until and unless the court releases that attorney from representation. So it's absolutely accurate that while I could sense there's clearly been a breakdown, Mr. Clayton doesn't get to make the call, and neither do you. Ultimately, I, as the judge presiding over the case, has to decide whether or not to release it. Did Did you have further points you wanted to articulate in response to the suggestion so far?
Other than Brian is more than welcome, and I can't tell you what to do, Your Honor, and I'm not trying to be disrespectful in any way, shape, or form, but I don't need Brian to represent me anymore. I don't want him to represent me after watching him 100% fail both me and my husband during my fiance during my fiance's trial. I don't need him to represent me anymore. I will find other representation, and if I can't, I might have to represent myself. I don't know. I've never been this far in a hearing before, but all I know is I don't need a man representing me who doesn't want to represent me because I don't feel he'll do his job.
All right, let's break this down a little bit. She is claiming that this defense attorney has promised to get her fiance off of his charges. Walk free and clear is how she worded it. Yeah, attorneys don't usually promise that. They will say that I'll do the best that I can, and with all the facts of this case, I should be able to do that. You know, that's potentially what he might have said, but very rarely would an attorney promise anything like that. I mean, I've heard attorneys say like you can't do that. You know, you can't promise anything because you don't know, especially if it was a jury trial. I don't remember what she said if it was a jury trial. So there's absolutely no way you could promise that. And as for the evidence and not calling her as a witness, is this the same case? They don't talk about the case at all because this is a hearing just to withdrawal, so they don't actually talk about what the charges are. But if it's the same case, that is a conflict of interest. He can't call you. What if you said something to hurt your case? And how is he able to represent both of them at the same time? It's just something weird is going on. So I'm guessing they're two different cases. Yeah. Anyways, she doesn't want him as an attorney, but we actually get to hear the prosecutor's side of this, who was the prosecutor, or at least in the courtroom during this exchange between her and her defense attorney after the fiance's case. Okay, let's hear what he says. Oh, also, he was very quiet. I bumped up his volume as loud as I could. He is still kind of hard to hear, but I think we can piece it together.
Did you wish to weigh in at all on this dispute, Mr. Rowland?
Your Honor, as an officer of the court, I feel not obligated to do so. And I understand, Your Honor, you were not present during the co-defendant's trial. I, in fact, however, was personally present, as was Mr. Singer, because he was one of the court officers. I can't say about any communications that may or may not have occurred between Mr. Coyne and Ms. Daniels, obviously out of my presence. However, what I can say is in the courtroom after the verdict, Ms. Daniels was threatening a number of people, Mr. Singer included. Additionally, as to the comment about Mr. Coyne somehow not doing his job because he wasn't going to let her testify, I also brought a motion to have Ms. Daniels advise of her Fifth Amendment rights if she was going to testify. And as my recollection indicates, and as I believe the transcript would indicate, she meant then a decision was made for her not to testify because she had these pending matters. I feel obligated as an officer of the court to correct the record in that regard. Thank you, Your Honor.
All right, thank you. Well, what is key?
All right, so I was right. It must be the same case or they're related in some sort. Yeah. You know, get your fiance to walk free and clear, but make you look like the bad guy and the charges stick on you. I mean, who is feeding her information? Is this her fiance upset? And you know, after he's in jail, they're talking on the phone, and he's upset. So this is where she's coming from, because she said she was sequestered, so she wasn't even there. She doesn't know what evidence was brought up at trial. All she knows is she wasn't called as a witness. That's all she knows. She wasn't there.
And what is unquestionable now is that there's been a breakdown of the attorney-client relationship between Ms. Daniels and Mr. Clay here. And the particular reasons why necessarily don't matter to me. The law allows me to allow Mr. Clay to remove himself as an attorney if he's fired. It appears clear that Ms. Daniels is asking me to release him as counsel, and so I'm going to do that both based on his request and stated concerns by Ms. Daniels. In other words, it's clear that there cannot be continued representation under these circumstances. So I'll grant your motion to withdraw. Mr. Clay, you'll just simply need to prepare an order, get it approved by form by the prosecutor, and then I'll sign it and release you as counsel. So your motion is granted. I find good cause to do that. Ms. Daniels, that affects in important ways, though, how we're going to proceed next. So, Mr. Clay, because I released you, you're free to sign off now if you want to. Just prepare that in order for my signature.
Yes, sir.
Thank you. So, Ms. Daniels, the next thing that has to take place is our discussion about what we plan on doing moving forward. Today, as you know, is September 4th. We currently have a trial date scheduled for you on November 21st and 22nd. So I have already had final status conferences. Everybody is already clearly aware, but I'll just repeat so that it's clear. You had the opportunity to consider pleas. You did not want to take them, and that's fine. That's why we're going to have a jury determine the issues in this case. As I recall it, we had a 2-day trial set before Mr. Rolla, when this matter is ready to try. Do you believe it's still a 2-day trial?
I think it's probably gonna be a day and a half, Judge. We might be able to get it in 1 day, but I can't guarantee that to the court because I have no control over what they decide to do.
All right.
May
Well,
I
you
say
have 4
something, Your Honor?
I'll come back to you certainly, but I do it in a one at a time type of situation. So let me hear from the prosecutor, then I'll definitely hear from you, Ms. Daniels.
As we were able to get the first trial in 1 day, and that's a reflection, it's gonna be the same witnesses. If it runs the same way, we can get it done in 1 day. Again, with that clarification.
So Ms. Daniels, I set this case for 2 days. You obviously know more about the co-defendant's case because you were there during the trial. Do you have any reason to think that this case is going to take longer than the other trial took?
Yes, I do, because my attorney will actually furnish the evidence and let my witnesses testify.
All right. So what I'll do is keep a 2-day trial on. Really, the question is this: what is your plan? You've now gotten your desired result, which is Mr. Crane is no longer representing you. He got his desired result too. But the end of that is right now you stand unrepresented and you're entitled to be represented. So are you planning on hiring an attorney?
Yes, I am. I've been looking for one legit since the last time Carl had court, July 25th. I've been looking for an attorney. I have not yet been able to find one because either they refuse to work in Otsego County or they want thousands and thousands of dollars. The cheapest attorney I have found is $30,000. I found a gentleman who said that he would represent me, but I had to wait until Mr. Clawyoun was released from my counsel, and I got to give him a call back. I do not know what his name is. I have a screenshot of his phone number, and I'm going to call him, but I have to find out how much he costs first because as of right now, I don't have a job. There's some stuff going on I'm sure you know about in Otsego County with my fiance and with CPS. It's a bunch of nonsense, but for the last couple of months, I've legally not been allowed to work. I had an interview this morning at 11:30. I called yesterday. The circuit county or the county clerk told me that my Zoom meeting was.
Wait, can we rewind a little bit? She's legally not been allowed to work. Someone explain that to me. Can you get a court order that you're not allowed to work? How does that make sense? Also, she just said on the record 10 minutes ago that the trial of her fiance cost her a job that could have paid her $2,300. Now she's contradicting herself. She seems very angry. She does.
At 10 this morning. So I sat on Zoom for a half an hour. And then my fiance called and was told that it was at 10:45. So I'm unable to go to my interview this morning. But I've found, I might possibly have found representation. I'm looking for representation. If I can't find any, I might have to represent myself. But I do want to state to Your Honor that plea that I was offered in the beginning, it wasn't my choice to not take it. Brian told me not to take it, that he could get me something offered better. And that was the.
Daniels, I'm not going to have a discussion back and forth about the plea because I would never have allowed a plea cutoff to come and go without addressing you personally. That never would have happened, and it did not happen. I would have and did address you personally to make sure that you understood, and it's your choice.
Yes.
If I need to have discussions about pleas in the future, then I might do so. There's obviously changed circumstances now that you're going to be seeking new counsel, and maybe I'll come down and readdress that potential road again in the future. I'm not going to do it today because it doesn't make any sense to do that today. I don't even know which attorney is going to represent you and if that has any change in the prosecutor's view of the case. So I'm not going to make any determination right now other than to just tell you I set plea cutoffs for a reason. I addressed you personally. I didn't just rely on your attorney, and that record has been made already. But what I intend to do is two things. I recognize that what you're saying is you intend to, or you're planning and you're wanting to hire counsel, but you may not be able to. So what I'm going to do is do two things. I'm going to give you a little bit of time to see if you can hire counsel, but I'm also at the same time going to make an order that you talk to what's called the MIDC, the Michigan Indigent Defense Commission here in Otsego County, to find out if you qualify for court-appointed counsel. You have to make an unequivocal request to represent yourself if that's your intent. If you ever make that request, I'll go through the warnings that are required. But this does not sound like an unequivocal request to represent yourself. And so instead, what I'm going to do is have you talk with that MIDC attorney. He or she is going to screen you. That's ask you questions about your finances to determine if you would qualify for court-appointed counsel. If you qualify for court-appointed counsel, I'm going to have the MIDC appoint that attorney. That way, you at least have an attorney. If you choose to hire a different attorney in the future, that's fine. You can always hire an attorney at any time. The attorneys know the paperwork to shift from one attorney to another. Do you have any questions about that process?
No, Your Honor.
So I'm going to give you a name and number that you're going to need to call, and I'm just going to require that you make that call within the next 14 days so that we keep the case moving. Do you have a pen and a piece of paper that you can write this name and number down?
I do, but I'm going to be moving and it might get a little loud because I got to go downstairs to get a pen.
That's fine.
All right, let's fast forward this.
8030.
All right, I got it.
So call him, let him know that I released your prior attorney and that I'm referring you to the MIDC so that you can get screened. He'll ask you questions. Again, he'll make a determination. And if you're indigent, he will appoint an attorney to represent you. Then you've got that attorney. If you choose still to hire another attorney, you can always do that, but at least then you'll have an attorney representing you. Do you have any questions? Any questions right now, Ms. Daniels?
No, I do not.
My inclination is that you getting a new attorney, whether hired or court appointed, necessarily should have an impact on the trial date. As you know, I have trial dates set on November 21st and 22nd. My concern is in a 2-month time period, a little over 2.5 months, that it's not going to be enough time for any new attorney appointed or retained to get fully up to speed. Do you tend to agree with that, Ms. Daniels?
I do.
Mr. Rolla, did you want to be heard on that point?
No, Your Honor, thank you.
So I'm not.
All right, 2 to 2.5 months is not enough time. No wonder the attorneys were asking for $30,000. I really want to know what these charges are. I'm going to go back and I'm going to look her name up. What do we got? Britta Daniels. Okay, I got to look that up to see what this case is all about. Probably should have done that before this so I could let you know. But if I do find anything, I'll throw it in the description. So once this video is out, check the description. There may be information on what the actual charges are. All right, but I'm going to let this video play out. I know I cut this clip off early because they start going through personal information at the end. So if it seems like it just ends out of nowhere, it's because the last 2 minutes of the hearing is just confirming personal information, and we don't need that on YouTube. If you haven't hit the like button already, please hit the like button. It does help the channel out a lot. You guys are awesome. I will see you later. Until next time, bye.
I'm going to continue the trial for November 21st and 22nd. This case is old. It's been around for a long time, and it does need to get resolved. But it also needs to get done in a way that allows the new attorney to get up to speed. So I feel compelled to, and I'm going to adjourn your trial. It doesn't make any sense for me to have that take place on November 21st and 22nd. So I'm going to take that trial date down. As I told you before, though, the new trial date that you get is not going to be stacked. It's going to be the trial that actually goes. So once your new attorney is on, Mr. Rolla, I'm sure that attorney will reach out to you, appointed or retained. If that results in a communication where you need a status conference, well, I'm going to set a status conference next month in any event, but if you need additional status conferences or discussions with the court, you and the new attorney can make those arrangements and we'll set the hearings. At this point, though, I'll bring you back in about 30 days so that I can have a follow-up and understand where you're at in the process. Have you been appointed a counsel, or are you going to hire attorneys? And we'll have a follow-up. That will give me then a reasonable basis to know when I should reset your trial. Do you have any questions, Ms. Daniels?
No, I don't. Well, I do, but it's not about this. Are children allowed to come to sentencing?
Children are allowed in any courtroom unless the presiding judge makes a ruling otherwise. And so you should check with the judge that's there. If you're asking for me personally, I generally don't want to see children in the courtroom, but I never have once prohibited them because I view that as a parent decision. I don't generally advise having children involved in adult discussions, but I don't prohibit them either. But each judge is their own person and they get to make determinations about their court. So if you're asking about another judge, I'm not giving you an answer.
Okay.
Mr. Roll, anything further on this record today?
No, Your Honor, thank you.
Ms. Daniels, anything further today?
No, Your Honor.
We'll see you at your next status conference. What's your current mailing address, Ms. Daniels?